Perfect.
Okay. So my screen is shared. You can see my screen well right now.
Yes.
Shall we start immediately?
Yes, please go ahead.
Okay. So welcome to our webinar titled Global Legal Protection of Geographical Indications. In our presentation today, we're gonna set out first an introduction to geographical indications, and then we're gonna talk about the differences between a geographical indication and other protections, such as the appellations of origin and indication of source, and how to distinguish them from a trademark. And most importantly, we're gonna focus on the protection of a geographical indication on a national level and overseas, in addition to the enforcement of a geographical indication. So, as per the TRIPS, the Trade-Related Intellectual Property, it defines the geographical indication as indications which identities a good as originating in a territory of a member country or a region, or locality in that territory where a given quality, reputation, or other characteristics is essentially attributed to its geographical origin. So the products identified by a geographical indication are often a result of a traditional process and knowledge carried forward by a community in a particular region from generation to generation. Similarly, some products identified by a geographical indication may embody characteristic elements of the traditional artistic heritage developed in a given region, and it is known as the traditional cultural expression, or the TCEs. The geographical indications are typically used for agricultural products, foodstuffs, wine, spirit drinks, handicrafts, and even industrial products. And as per the TRIPS agreement, in order to protect a geographical indication, it needs to be an indication. It not necessarily needs to be a name, a geographical place, or a place on Earth. In other words, a geographical indication could be an iconic symbol like the Eiffel Tower to designate a French good, or the Taj Mahal to designate an Indian good, or the Statue of Liberty to designate an American good. So it's worth noting that the WIPO, the World Intellectual Property Organization, is the umbrella organization for the protection of geographical indications, where multilateral treaties have been administered, such as the Paris Convention for the Protection of Industrial Property, the Madrid Agreement, the Lisbon Agreement, which is a very important agreement in our presentation today, and the TRIPS Agreement. The geographical indications have been given the status of intellectual property since the product gets more value commercially by its mere association with a particular place. Geographical indications, they help in the identification of a source of a good, which in turn is related with the quality of the good. They do not directly protect the subject matter generally associated with the TCEs or the traditional knowledge as we know it, which remains in the public domain under the conventional IP system. However, the geographical indication may be used to indirectly contribute to their protection by preserving them for future generations. A protected geographical indication does not enable the holder to prevent someone from making a product using the same technique as those set out in the standards for that indication. Protection for geographical indication is usually obtained by acquiring a right over the sign that constitutes the indication. The right of a geographical indication enables those who have the right to use the indication to prevent its use by third parties whose products do not conform with the applicable standards. Here we're going to show you some very famous examples of the geographical indications, which we have the feta cheese, the Tuscany and the Bordeaux wine, the Dijon mustard, the Parma ham, the Parmigiano Reggiano cheese, or as known as the Parmesan cheese, and the Darjeeling tea. So now we're going to set out the differences between the geographical indication and other protections. As per the differences between the appellations of origins, indications of source, and geographical indication, here we set out a small chart indicating the differences, which we can notice that the indication of source is a totally different concept from the appellations of origins and the geographical indications, where the indication of source is only identifying the geographical origin of a product, while the appellation of origin, in addition to that, it needs to have a special quality and characteristic. And the geographical indication, in addition to all of the mentioned, it needs to have a special reputation. So the appellation of right or appellations of origin refers to the geographical name of a country or a locality. For example, the Champagne, which serve to designate a product originating therein, whose characteristics are exclusively essentially due to that geographical environment, including natural and human factors. While the geographical indication, it identifies a good originating in a territory of a member country of a region, or a locality in that territory, where a given quality, reputation, or other characteristic of goods is essentially attributed to its geographical origin. In the appellation of origin, the link with the place of origin must be stronger in the case of the appellation of origin. The quality or the characteristic of a product protected as an appellation of origin must result exclusively or essentially from its geographical origin, while in the geographical indication, a single criterion attributed to the geographical origin is sufficient. Its quality or other characteristic of the product or only its reputation is sufficient to consider it a geographical indication. In the appellations of origin, this generally means that the raw materials should be sourced in the place of origin, and that the processing of the product should also happen in that origin. While in the geographical indication, the production of raw materials and the development of the processing of a geographical indication do not necessarily take place entirely in the defined geographical area. And here we're going to show you, and a number of traditional indications that are not place names but refer to a product in a place are protected as an appellation of origin under the Lisbon Agreement. For example, the Replicon cheese and the Vino Verde, the green wine. It's sometimes argued that the products with a certain reputation but not other quality due to their place of origin are considered as appellations of origin under the Lisbon Agreement. And this agreement, the Lisbon Agreement, it defines the terms appellations of origin, and it brought it to the field of protection with the geographical indication. And now we're going to show you some famous examples of appellations of origin. The first famous example is the Prosciutto di Parma, or as known as the Parma ham. For ham to receive the Parma name, it must be produced in the province of Parma, in the Emilia-Romagna region of the north central of Italy, using exclusively pigs from that area. Each step in production, from the breeding of the pigs and their diet through their processing to the final packaging, is also monitored and controlled by the Istituto Parma Qualità, or the Institute of Parma Quality. As well, we have another example, it's the tequila from Mexico. Tequila production is governed by the federal regulations that define where the tequila can be made, where the agave plants need to be made or grown, what needs to be stated on the label, where it can be bottled, and how much content or percentage of agave sugars can be used. So when you see a bottle labeled tequila, you know that you are getting the real thing. As per the differences between an indication of source and the geographical indication, as I mentioned earlier, the indication of source is a totally different concept. While the geographical indication needs a special quality or a reputation or a characteristic of the product, which is essentially related to the place of origin, the indication of source, it doesn't need any special quality or reputation or characteristic. of the product, which is essential to the place of origin. The geographical indication is a unique product based on its own geographical area or traditional knowledge using the geographical indication. It helps consumers delineate traditional products from fake goods and provides consumers with a greater certainty of that product characteristics. While the indication of source, we can define it as an indication referring to a country or a place in that country or a place of origin of a product. It's not the indication of source, it only requires that the product on which the indication of source is used is produced in a certain geographical area. Such example, when we put on the labeling of a product made in China or product of USA, this is considered as an indication of source. Now we're going to show you how to distinguish between a trademark and a geographical indication. A trademark can be a word, a letter, a numeral, or a combination of numerals and letters. It also may be a hologram, a sound, a smell, an abbreviation, and even a device. While a geographical indication can only be names or symbols corresponding to a particular region or a place. A trademark identifies a good or service originating from a particular company, while a geographical indication identifies a good originating from a particular place and not a company. A trademark is owned by a single owner who shall have the right to prohibit unauthorized owners to use his trademarks. As well, a trademark may be assigned or licensed to anyone, anywhere in the world, because it's linked to a specific company and not a particular place. While a geographical indication, it's worth noting there is no single owner of a geographical indication, or more effectively, it can be said that there is no real owner of a geographical indication. Any single person who used the same techniques and standards in a specific origin can use such geographical indication. And any person who produces according to the specified standard because of its link with the specific origin, a geographical origin, it cannot be assigned or licensed to someone outside that place or not belonging to the group of authorized producers. And now we're going to talk about the most important part of our webinar today, which is the protection of a geographical indication on a national level as well as overseas. So the potential obstacles that you might face while registering a geographical indication is to have a conflict with the prior mark, that the geographical indication contains a generic character of the term that constitutes a geographical indication. You might face an existence of a homonymous geographical indication, which is considered to mislead the product's true origin. Or the indication of source, its name of being of a plant variety or an animal breed. And finally, the lack of protection of a geographical indication in its country of origin. In contrast to the Lisbon Agreement, the TRIPS Agreement obliges the WTO or the World Trade Organization members to directly implement the agreement provisions into existing national legislations. Even so, members were allowed to choose appropriate ways to implement. As a result, the members did choose to introduce specific legislation. Some countries opt for passive protection, and others opt for protection of registration. In countries with passive protection, any interested party may bring an action before a court against any person carrying any of the following acts: the use of a geographical indication in relation to any good which did not originate in the place indicated by a geographical indication, in a manner which misleads the public to geographical origin of the goods, or any use of a good or indication which constitutes an act of unfair competition with the meaning of Article 10 of the Paris Convention. So, when filing a protection of a geographical indication on a national level, a request of protection may be filed depending on the applicable law in this jurisdiction. In many countries, an applicant whose residence or principal of place of business is outside the country where the protection is sought, he must be represented by a lawyer or a local agent which is admitted to practice in that country. The practical steps which needs to be taken vary depending largely on the purpose and the geographical scope of the protection of that the applicant desires. In the broadest terms, if the applicant is considering protection limited to the national level, then his first port of call should be his IP office or intellectual property office, or the regional competent authority in charge of a geographical indication, which advisably needs to be done by a local lawyer or a local agent. We know that there is a debate on the protection of a geographical indication beyond wines and spirits products. So here we're gonna state some articles from the TRIPS agreement in relation to this matter. So the Article 22 of the TRIPS agreement states that governments may refuse to register a trademark or may invalidate an existing trademark if it misleads the public as to the true origin of a goods. However, governments may refuse to register or may invalidate a trademark that conflicts with a wine or spirits geographical indication, whether the trademark misleads the true origin or not. And Article 23 of the TRIPS agreement states that all governments must provide the owners of a geographical indication the right under their laws to prevent the use of a geographical indication identifying wines not originating in the place indicated by a geographical indication. This also applies even when the public is not being misled and when there is no unfair competition. So in most countries, geographical indications are not only limited to wines and spirits, but they also include agricultural products, foodstuffs, handicrafts, and even industrial products. And since 2011, while in the Doha development round of the WTO negotiations, some governments are wishing to go further and negotiate the inclusion of geographical indications on products other than wines and spirits. And since 2011, the Directorate General for the Internal Market Industry, Entrepreneurship and SMEs has been considering the opportunity of extending geographical indication protection at the EU level to non-agricultural products. However, currently such protection is only provided for agricultural products and foodstuffs, wines, spirit drinks, and aromatized wine products. Also, the WTO member governments are negotiating the creation of a multilateral register of a geographical indication, when some countries, including the EU, are pushing for a register with legal effect, while other countries, including the United States, are pushing for a non-binding system which the WTO would simply be notified of the members' respective geographical indications. And now, as per the protection of geographical indications globally or overseas, we know that geographic indication rights are territorial. This means that these rights are limited to the country or region where protection is granted. So there are currently four main ways of protecting a geographical indication globally. Our first option is by obtaining a protection directly in the place of jurisdiction concerned. In general, in order to get protected, in order to protect a geographical indication in their territory, many jurisdictions require that the geographical indication needs to be already protected in its country of origin. Once a geographical indication is protected in its country of origin, it would be possible to seek other jurisdictions under the means of protection available in these jurisdictions. Our second option would be by taking advantage of bilateral agreements concluded between countries. Bilateral agreements are typically concluded between two countries based on reciprocity. This may be limited to economic sectors or products, such as the wines and spirit drinks. Our third option and which we believe is the most important option, and we're gonna talk about this more in our presentation today, is through the WIPO's Lisbon system for the international registration of appellations of origin. The Lisbon system offers a means of obtaining protection for an appellation of origin already protected in one member state in the territories of all other members. This could be done through a single registration called an international registration. And finally, our fourth option is through the Madrid system for the international registration of marks. To avoid filing a trademark application in each country where the protection is sought, it may be possible to file a single international application using the Madrid system. And now we're going to focus on the Lisbon Agreement for the international registration of the geographical indication. The Lisbon Agreement extended to geographical indication by the Geneva Act of the Lisbon Agreement, which allows the international registration of a geographical indication or a GI. In addition to the appellation of origin and permits the accession of a Lisbon Agreement by a central intergovernmental organization. In fact, the Geneva Act bridges the Lisbon system appellation of origin and the TRIPS system for the geographical indication. So if the applicant is considering protection in more than one territory, then WIPO's Lisbon system could be the most appropriate and suitable option. We're going to give a small overview of the Lisbon Agreement. It is established to facilitate the international protection of appellations of origin through a single registration, and it defines the appellation of origin as a geographical denomination of a country, region, or locality which serves to designate a product originating therein, the quality or characteristics of which are due exclusively essential to the geographical environment, including natural and human factors. The Lisbon Agreement is administered by the WIPO, which keeps the international registration of the appellations of origin and the geographical indications. The Lisbon Agreement constitutes of 37 contracting parties, covering 56 countries in Africa, Asia, Europe, Latin America, and the Caribbean, such as Algeria, Bulgaria, Cuba, the whole European Union, France, Italy, Morocco, Spain, Tunisia, and Turkey. The Lisbon system sets a legal framework to facilitate the international protection of geographical indications and appellations of origin without the difficulties and costs of filing and managing multiple registrations before different authorities. Through a single registration procedure in the WIPO, in one language and with only one set of fees and in one currency, the Lisbon system grants the geographical indication protection in several countries based on the legally binding international register. The Lisbon system can be used to protect appellations of origin and geographical indications for any type of product, such as agricultural products, foodstuff, natural, artisanal, and even industrial goods. There's only one condition to be able to register your geographical indication internationally under the Lisbon system. To qualify for international protection, the geographical indication must be already protected in its country of origin by means of either legislative or administrative provisions, judicial decisions, or any form of registration. The Lisbon system leaves flexibility on how the protection must be formalized on the national level, which may be determined by the applicable laws of the country of origin. Registering the International Register of a Geographical Indication under the Lisbon system is a very simple and flexible procedure. After conducting a formal examination of the international applicant, the WIPO notifies the other contracting parties to the Lisbon Agreement of any new registration received. Each contracting party is then free to decide whether to protect a newly registered GI or to refuse the protection in its territory. Refusals can be issued on any substantive legal grounds existing in the national framework and must be notified to the WIPO within 1 year of the notification of the new registration. The international registration under the Lisbon system is unlimited in time, and there is no renewal needed. Once the geographical indication is registered, the consequent international protection is potentially unlimited in time, and there is no need to pay any additional fees to renew the registration. In principle, the international protection lasts if the geographical indication remains valid or protected in its contracting party of origin, subject to any refusal with any prescribed term or invalidation principles. You can use the Lisbon system to protect your appellations of origin or geographical indication. Here we're gonna sum up everything we said. If the geographical indication that you want to register is linked to one or more of the contracting parties to the Lisbon system. Second, under the law of contracting party, you are the beneficiary and you are the legal owner, and you legally have the right to use such geographical indication. And third, the geographical indication is already recognized and protected in its contracting party of origin by virtue of a domestic legal title, such as registration, a legislative or administrative act, a judicial or an administrative decision. It's worth noting that the domestic title of protection is the basis and the condition for the validity of the international registration under the Lisbon system. And now, as per the enforcement of a geographical indication on third parties, as we have mentioned before, a protected geographical indication does not enable the holder to prevent someone from making a product using the same techniques as set out in the standards of that indication. A protection for a geographical indication is usually obtained by acquiring a right over the sign that constitutes the indication and not the indication itself. And like all intellectual property rights, the geographical indication are enforced by application of national legislation, typically in a court of law. The right to take action could take place with the competent authority, the public prosecutor, or to any interested party, whether a natural or a legal entity, whether from the public or from the private sector. The sanctions provided in a national legislation could be civil, such as injunctions, restraining or prohibiting unlawful acts, or action for damages. The sanctions may as well be criminal or administrative. So how the geographical indication is enforced? In conclusion, we can say that geographical indication is enforced through the data collection from the member states, through the criminal laws enforced in a specific jurisdiction, or through civil law remedies like the intellectual property laws, the unfair competition laws, and the consumer protection laws. So we're going to thank you for your attention. This is everything we need to say related to the geographical indications and its protection on the national level and abroad. And if you need any clarification, please do not hesitate to contact us on our company email. Thank you.
Perfect. Well, thank you so much. I found that very interesting. Always fun to learn new things. So if anyone has any questions, please do raise your hand now or send a message in the chat box. Otherwise, I think we'll end the session there. And then if you've got any questions, you're more than welcome to email me and I'll pass it on to Nasser and his team. Or as you can see, their details are available on screen. So please feel free to get in touch with them as well. Okay. Let me just see if we've got any questions. No. Okay, well, Nasser, I think we'll end it there. Thank you so much for the presentation. And the recording will be made available to those who ask for it. So I will share the link with the attendees and yourself, Nasser, as well. Other than that, wishing you all a lovely day and a
Have a
lovely
nice
week.
day.
Thank you.
Thank you. Thank you for your time.
Thanks.
Have
Bye-bye.
a nice